Good evening and welcome to the August 2015 Richardson Law Office's Legal Hangout. Today we're going to talk about student loans and bankruptcy and ways in which you can get them discharged. And really go over with you what the criteria are to get a student loan discharged in bankruptcy. Give you an idea so you can apply the test to your situation and see what your chances are in getting that, using bankruptcy to discharge your student loan. Now, certainly nothing replaces a consultation with an experienced bankruptcy attorney in your area to see whether your case could result in a bankruptcy discharge. But here it'll just sort of give you a general idea of what your chances are. And what I'm talking about here is more a discharge of state or private student loans as opposed to federal loans. And I'll get into why in a minute. But understand that this process is really the only way of discharging a state or private student loan. There's some other options with federal loans. Now, to give you a little bit of history so you understand what the criteria are used by the court. Back in the early 1980s, a woman by the name of Brunner in New York was seeking to have her federal student loan discharged. And at that time, you could discharge a guaranteed student loan, at that time just loans guaranteed by the government, backed by the government, if the loan was more than 5 years old. If it fell due and you had to start making payments at least 5 years ago, you'd file bankruptcy and it would be discharged just like credit card debt. Okay? You wouldn't have to meet any particular criteria. But if you wanted to discharge it within those first 5 years, then you had to show undue hardship, according to the standard, which I'm going to go over with you. Now, in subsequent revisions to the Bankruptcy Code, that 5-year period became 7 years. Then the 7-year period was eliminated, and the undue hardship test was applied to any situation in which a government-backed guaranteed student loan was sought to be discharged by the debtor. Then in 2005, with the Bankruptcy Abuse Protection and Consumer Protection Prevention, Bankruptcy Abuse Prevention and Consumer Protection Act, otherwise known as BAPCPA, the changes to the Bankruptcy Code in 2005, any student loan, whether it's federal, state, or private, even if it isn't government-backed, has this protection where you have to show undue hardship. So we went from having to prove it if you want to discharge within 5 years, to within 7 years, to wanting to discharge it at all. So this woman named Brunner in the Second Circuit, and then the other circuits within the federal court system basically looked at Brunner and said, oh, what a good idea. We're going to adopt this as well. Most federal districts adopt this 3-part Brunner test. There are a couple of circuits, and yours may be one of them, so bear this in mind, and this is why you need to talk to an experienced bankruptcy attorney. Some of them use what's called a totality of the circumstances test. It's a somewhat broader one, and it's very fact-based on what your situation is, on whether that student loan should be discharged. So be aware that the 3-part test I'm about to go over is only for those federal districts, like the Third Circuit. I'm sorry, federal circuits, not districts, like the Third Circuit that we're in here in New Jersey, that apply this Brunner test. And in the Third Circuit, it's called the FAISH, or in re FAISH test. That's our Third Circuit case that said we're going to adopt the Brunner standard. Now, the Brunner standard is the 3-part test, and you must pass all 3 of these tests if you ever hope to be able to discharge a student loan. The first test is you must prove that you would not be able to maintain a minimal standard of living should you be forced to make the student loan payments. And minimal is really pretty minimal with a lot of the bankruptcy cases that have applied this test to people trying to get a discharge of student loans. People that are on SSI, disability income, barely getting by. And so that you really cannot maintain that minimal standard of living. You can't have a decent life if you have to pay these loans back. The second part of the test is that this must be a persistent state of affairs. In other words, this situation that you're in, where you can't maintain a minimal standard of living if you're forced to repay the student loan, is going to continue on for a significant period of time. It's not just a temporary situation. It isn't going to go away anytime soon. This is basically what you're living now is the way you're going to be living on into the future. The third prong, the third test you must pass, is you must show that you made some good faith effort to repay the loan. And so you can't just say, well, I'm just not going to pay it. I can't afford it, and that's it. There has to be some effort to repay it, partial payments, something that you did to try and to deal with it. Now, that's a tough test, and you got to pass all three of them. The idea of the minimum standard of living and the persistent state of affairs, case law talks about, and this is how harsh it gets, talks about a certainty of hopelessness. That's how bad it is, okay, in doing this. Now remember that these cases came out in the 1980s when people had to meet the standard if they couldn't wait 5 years to discharge their student loans. They had to do it now. And that's where you can understand then, in that context, why there is that persistent state of affairs requirement. Look, is this pretty temporary? You know, you just graduated from college or graduate school or professional school, whatever it is, and you just graduated and now you're saying you can't pay your student loans. Yeah, you don't have a job now. Yeah, you're not making a lot of money now. But in the next couple of years, is that going to change? Is it going to change within that 5-year period? Is it going to get better? Or is it never going to change? In other words, are you in a situation where you really can't wait that 5 years, that 7 years? That's kind of moot now that they've removed that requirement, that 5 or 7 year period of time. Now it's anytime you want to discharge. But it gives you a better understanding of why they have that persistent state of affairs requirement in there, and also the good faith payment. Look, did you even try to make some payments? Did you make some payments for a couple years and then you just couldn't do it anymore, or you fell on hard times, or you became disabled, or something happened where you couldn't make the payments anymore? So understand it in that context. So that is what you have to prove. So look at your situation, really. You know, how bad is it? Now, why I say this is more for private loans and state loans is that under the federal system, there are other ways to deal with your student loan if you can't afford it. Okay? A lot of programs have cropped up since the Brunner and Faish cases have come out, where people were trying to discharge student loans, where they came up with all sorts of additional programs where you could extend your payment period. If you owed more than, now it's more than $30,000, you could extend your payment period from 10 to up to 30 years. You'll pay a lot more in interest, but your payment will be a lot lower. And they've come up with income-based repayment plans, and this is the real killer when it comes to trying to discharge student loans in bankruptcy, federal student loans in bankruptcy, and that is this. If your situation is such that you have that certainty of hopelessness, you're making a minimal amount of money, you just can't afford it, well, chances are, under an income-based repayment plan, and depending on which one you're in, your payment can be capped at anywhere from 10 to 15% of your disposable income. And sometimes that cap can result in a zero payment. So if you're so badly off, if you really do meet that Brunner-Feisch test, then maybe your payment under an income-based repayment plan would be zero. You're unemployed. You're making very little money. Well, what do you mean you can't afford zero? So that's the first argument that the government is going to make in bankruptcy court if you try to discharge a federal student loan on the Brunner test. They're going to say, what's wrong with zero? You can't afford zero? And it's just not going to work. So I would suggest to you that if you have federal student loans, that you first talk to an experienced student loan attorney or your servicer about some other payment plans. It's something that is more affordable than your basic 10-year fixed monthly payment, because that's really the best way to deal with federal student loans. With state or private loans, that you may well be more likely to be able to establish that, because if you have a significant amount of money in a private student loan, for example, you've used private loans to fund most of your undergraduate and graduate school, you're a physician, you're a lawyer, some of these professionals or people that get advanced degrees and have really run up a lot in private student loans, to the point where the monthly payments together on all the loans could be $2,000, $3,000. And there's no way, no matter how much you prune your budget, okay, no matter how much you cut things back, you're never going to be able to afford to live if you've got to pay $2,000 to $3,000, for example, in student loan payments. And certainly, you know, and be aware that under this test, one of the things they look for, and one of the things you need to look at, is what is your current situation? In other words, are you underemployed? Are you working in your field? There are cases in which people have tried to discharge student loans, and the courts looked at them and said, look, you have a degree in engineering, and you're working for a nonprofit for peanuts. You're way underemployed. You have what efforts have you made to get work in your field? Because work in your field is going to pay you a lot more. And you know, is it a situation where you just haven't been able to find a job now? Well, what if the job market improves? What if you're able to get a job later on in your field? It goes to that persistent state of affairs. So that can be an issue as to whether, you know, where you're working, what you're doing, and how long you have been struggling with this. How long, you know, have you been, you know, for the past 5 to 7 years, have been sending out resumes and trying to get work and trying to get a better income, but the best, despite your best efforts, the best you've been able to do is what you have, and what efforts have you made to repay partial payments, things like that. So that is what they're going to look at, and it's a harsh standard, unfortunately. But the more outrageous the payments are, the less likely a court is going to say, well, you know, if you tighten your belt a little bit more and you didn't spend quite so much on such and such, or instead of driving a Lexus, you drove a Ford Focus or something, and nothing against either car, but you get the idea that maybe you could trim the fat a bit, tighten your belt, and pay less, and then maybe you can afford it. When you start getting into payments that are $2,000, $3,000, $2,500, whatever, you're getting into an area where the bankruptcy court judge is going to say, yeah, I mean, no matter what you do, no matter how you tighten it, you're just not going to be able to make that payment. Now, it could result in there might be a partial discharge. The bankruptcy court may discharge some of the loans, but not all of them, to try and cut back on what you have to pay, and may sort of split the baby a little bit. But as I said, it's a harsh standard. And another thing to bear in mind too, going back to federal loans, there are ways to discharge them outside of bankruptcy. So, if you have that persistent state of affairs, for example, if you are disabled, you're permanently disabled, there is a way to apply to have the loan discharged. You're permanently disabled. You're never going to be able to work. There's no use getting into an income-based repayment plan where you're going to, have a zero payment for 20 to 25 years. Wait that long. Look, you're never going to be able to afford it, and the U.S. Department of Education will then let you off the hook if you can establish that permanent total disability to their satisfaction. And usually, if you have a finding by the Social Security Administration for disability, permanent disability, on a 5 or 7 year review, then that's usually enough for the Department of Education to declare you disabled and discharge the loans. So really what I would suggest to you in this whole conversation is if you've got student loans and they're federal, don't try. Your first step should not be looking at bankruptcy. See, you may be, if you have other problems, other debts, a lot of credit card debt, things like that, where bankruptcy may be able to clear your debts financially, and get rid of other debt, the credit card debt, medical bills, that would then make it easier for you to make that federal student loan. Then you're prioritizing your debt, and bankruptcy can help you in that regard without discharge. But really, for federal loans, bankruptcy discharge is not your first choice. And also bear in mind that there's a dollars and cents aspect to this. It costs money to seek a discharge of a student loan. Most bankruptcy attorneys, depending upon your area, fees can vary, will charge a flat fee to handle a bankruptcy for you. But if you're trying to discharge a student loan, that's not going to be part of the flat fee. And the reason for that is that it is non-dischargeable unless you as the debtor bring what's called an adversary proceeding, which is like a lawsuit within bankruptcy court, serve the loan holders, the lenders, and basically prove to the judge that you meet that standard. Well, that attorney is going to charge you by the hour to do that. And it can cost you a significant amount of money to try and discharge a student loan bankruptcy. And you have to look at how much you have in loans too. If you have $15,000, $20,000, $25,000 in student loans, it can easily cost you half that just to get the other half discharged. Depending upon what area you're in and what the hourly rates are of bankruptcy attorneys in your area, it's a real dollars and cents thing. But if you have well over $100,000 in private or state student loan debt, and your state doesn't have programs like the federal government, then that's you may have to go with bankruptcy. And then with that much student loans balances, it makes more dollars and cents. It just becomes a matter of how do you afford the attorney? How do you get them how do you afford their bill for them to bring the adversary proceeding? So, federal student loans, other programs. Talk to an experienced student loan attorney or your servicer on what you can do with federal loans. Private or state loans, look at how much you have in loans. It may not be, it may be cost prohibitive to try and discharge them, even if you meet the standard that we've been talking about. And I guess the good news is, ironically enough, that the larger the amount of the loans, the larger the monthly payment, the easier it is going to be to show that you can't maintain a minimal standard of living if you have to pay the student loan because the payment's so high because you owe so much. And if you owe a lot of money, then it makes more dollars and cents to pay a fee to an attorney to have it discharged in bankruptcy under this tough standard. So hopefully that gives you a good idea of where you might stand with regard to dealing with student loans and getting them discharged and what options you may have. If you have further questions or need further information on that, you can leave a comment in the comment section of this video, or you can email me at steve@richardsonlawoffices.com. And I can either help you or refer you to a student loan lawyer in your area to try and see what your chances are of getting rid of these student loans. Of course, if you live in the Gloucester County, New Jersey area, down here in South Jersey, and would like to talk to me, pick up the phone, give me a call, 856-686-9910, and we can set something up, take a look at your situation, and I can give you a better idea where you stand with regard to your student loans in trying to discharge them or get an affordable payment. So that's it for this show. If you liked it, please hit that thumbs up button down below to like it. If you are interested in seeing further episodes, just hit that subscribe button and subscribe to the channel here at richardsonlawoffices.tv. We have these episodes every month on the fourth Thursday. And I am planning to add content, so there'll be more than one show per month, and see where we're going from there. Next month, the show is going to be on September 24th at 5 p.m. And we're going to talk about something that's been developed in New Jersey law fairly recently, in the last year or so, called a conditional dismissal. In New Jersey, in the criminal system, there is sort of a one bite at the apple, what's called a diversionary program, where if it's your first brush with the law and it's usually a nonviolent crime or something like that, and there is a way of staying out of jail and of sort of avoiding that stigma. And there's something called conditional discharge, which is used for drug possession programs in municipal court. And there's something called pretrial intervention at the county criminal level for felonies, things like that. But for non-indictable misdemeanors, which in New Jersey we call disorderly persons offenses, the perfect example is shoplifting. There is a new program called conditional dismissal that might help you avoid that stigma. So we're going to be talking about conditional discharge next month, conditional dismissal, excuse me, next month, and what it is, how it works, whether you might qualify for it. So if you or a friend or family member is running into this problem and might benefit from a conditional dismissal, please be sure to have them tune in next month. So, that's it for August of 2015 for our Richardson Law Offices Hangout, and I'll see you next month.